There's a set of theories in constitutional interpretation that are called at various places the philosophical approach, or the moral reading, or moral fact theories. These theories state that when interpreting the Constitution, one can't avoid attempting to answer philosophically difficult moral questions. There are morally difficult terms written into the Constitution. To illustrate the point of this theory, consider the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of differences. Note that the First Amendment doesn't create any rights. It doesn't say the government hereby grants to the people a right to whatever. It's written on the assumption that prior to the Constitution being written, people had such rights. And whatever that right is, the government shall not abridge it. So, what are the limits of government power? We first have to determine what's true of these rights. Once we know what the rights are, we can know what the government shall not infringe. How do we know what the rights are? Well, we engage in philosophical inquiry. Evidence that the authors of the Constitution took themselves to be referring to natural rights and duties that existed prior to and independent of the writing of the Constitution can be found in the Declaration of Independence. Quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed." Unquote. Here, the right to life, liberty, and the pursuit of happiness aren't granted by any government to determine if some government policy or program or governments themselves violate or protect a right. One doesn't look at what the government permits or allows. After all, governments can be destructive of our rights, something that is impossible if our rights are given to us by governments or constitutions. Here are some other examples. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated. It doesn't say that the government is granting a right to be secure in one's persons, houses, papers, and effects. It's stating that the right already exists, and that whatever the limits of this right happens to be, the government promises not to violate those limits. And we have the Eighth Amendment stating, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted," end quote. What counts as excessive? It's a bail or fine that violates the moral law. It's a bail or fine that is beyond what moral decency allows. When is punishment cruel? It's not when the Founding Fathers would have disapproved. It's whenever any decent moral person would have disapproved. If it turns out that the Founding Fathers embraced and inflicted cruel punishments on people, this would be a case in which the Founding Fathers violated their own Constitution. We have the Ninth Amendment, which states, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people," end quote. This makes no sense except as a statement that says that there are rights out there that weren't named in the Constitution. There are rights perhaps waiting to be discovered. However, they still exist, and the government shall not violate these rights either. To illustrate moral facts theory, let me compare it to how an originalist might interpret the Eighth Amendment. Again, the Eighth Amendment states, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted," end quote. First, the originalist argument. Did the authors of the Constitution judge capital punishment to be cruel? It's quite obvious they didn't think that capital punishment violated the Eighth Amendment because they wrote the Fifth Amendment, which says in part, quote, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb," end quote. And another part of that same amendment, quote, "Nor be deprived of life, liberty, or property without due process of law," end quote. Obviously, the authors of the Bill of Rights believed that a person could be legitimately deprived of life in other situations, which means the capital punishment can't be a violation of the Eighth Amendment. The originalist would also look at historical records and discover that capital punishment was widely practiced at the time. The moral fact theorist would say that the fact that people at the time didn't believe that capital punishment was cruel doesn't imply that it's not, in fact, cruel. Just as a group of people can falsely believe that slavery is somehow compatible with all men are created equal, they can falsely believe that capital punishment is not cruel. Here's another example. An author of the Constitution might have believed that some specific individual was eligible to run for president, and this is because they believed that the person was at least 35 years of age. But let's assume they were mistaken. This individual was only 30. The fact that the authors of the Constitution believed that this 30-year-old person was eligible to be president doesn't imply that we must therefore interpret the Constitution as saying that this person was eligible to be president. Instead, we dismiss their belief as a mistake. By analogy, the fact that the authors of the Constitution believed that capital punishment was not cruel doesn't imply that we must interpret the Constitution as saying that capital punishment is not cruel. We can dismiss that belief as a mistake. How then does moral facts theory differ from living constitution theory? One way to note the difference is in terms of fidelity to the Constitution. Living constitution advocates argue for weighing what the Constitution says against other moral and pragmatic considerations, and sometimes fidelity to the Constitution gets outweighed. When this happens, it's legitimate on living constitution grounds for judges to render a decision that, for all practical purposes, amends or changes the Constitution to take into consideration those moral and pragmatic concerns. Again, let us look at the Eighth Amendment. In 2005, in the case of Roper versus Simmons, the Supreme Court ruled that the execution of people who committed crimes as juveniles was unconstitutional. Simmons, at the age of 17, with the help of 15-year-old Charles Benjamin, broke into the home of Shirley Crook, put her in a van, drove her to a bridge, tied her up, and threw her off. Simmons was sentenced to death. The Supreme Court ruled that the punishment of death for juveniles was unconstitutional. In their argument, they appealed to a social consensus against such executions. They noted that states didn't consider those under the age of 18 to have sufficient judgment to drink or vote. Many states that still had capital punishment didn't apply it to those under 18, and almost no other country allowed the execution of juveniles. So the court ruled the meaning of what counts as cruel has changed, and they used as evidence facts showing that people tended to be opposed to the execution of juveniles. This was known as the evolving standards of decency argument. To determine if the execution of juveniles was unconstitutional, one looked at contemporary opinion on the matter. Now, moral facts theory may have reached the same conclusion, but public opinion wouldn't matter. What would matter is whether the execution of children was, in fact, cruel and unusual. Current opinion is just as irrelevant as the opinion of those living 250 years ago. Actual cruelty is what matters. Perhaps I can make this clearer by looking at a case outside of the Constitution. Assume that a museum has a Rembrandt room and a rule that only Rembrandt paintings may appear there. There's a painting being displayed in the room that experts later discover to have not been painted by Rembrandt. How would the two theories judge whether the painting could be displayed in the Rembrandt room? Something like a living constitution theory applied to paintings would ask whether the painting is currently believed to have been painted by Rembrandt. They'd be interested in public polls of opinions. If the polls suggest that people believed that the painting was a Rembrandt, then it would be considered a Rembrandt for the purposes of this rule. This means that if the experts were convinced that the painting is not a Rembrandt, but the people refused to accept what the experts said, the people would win, and the painting will stay in the room until the people are convinced that it's a forgery. Using what we might call the painting fact theory, we look at whether the painting actually is a Rembrandt. We may seek expert testimony. If the objective evidence shows that the painting is not a Rembrandt original, then it must be removed from the Rembrandt room, even if the people refused to believe it. Well, then, applying this distinction to the Eighth Amendment, living constitutionalist would look at opinion polls and the practices of the people to determine if they judge that executing children is cruel. Moral fact theorists would look at the philosophical debate over whether the execution of children counts as being cruel to children. Here we're suggesting that it's possible for something to be true even though it's widely believed to be false, or false even though it's widely believed to be true. But we can look at statements like vaccines cause autism, or the 2020 elections were stolen, or greenhouse gas emissions are not warming the planet, to refer to things widely believed even though they have been proved false. And while listening to this debate between the living constitutionalist and the moral fact theorist, the originalist would freak out over any theory that gives judges the authority to determine what the moral facts are and to force their opinion about the moral facts on us through their interpretation of the law. So as a recap, in this video and the previous two videos, I presented three views of constitutional interpretation. Originalism. What is cruel is what the authors of the Eighth Amendment would have judged to be cruel. Living constitutionalism. What is cruel is what people today judge to be cruel. And moral fact theory. What is cruel is what is, in fact, cruel. In the next videos, I'll be looking at arguments for and against each of these views.